An invitee is a person who's invited to enter another's property for their mutual benefit. One common example is a patron at a place of business. An invitee injured by a dangerous condition on the property may recover under a theory of premises liability, provided that all necessary elements are proved. The Iowa Supreme Court considered whether a bar patron injured by falling ceiling plaster had a viable premises liability case in Richardson versus Commodore. Russell Richardson was shooting a game of pool at the Commodore Tap, a bar owned and operated by Ralph and Betty Hauerwas, when a piece of ceiling plaster fell and hit him on the head. The bar was located on the first floor of a two-story building from the early 1900s. Before opening for business in the 1980s, the Hauerwases repaired those portions of the building's original plaster ceiling that were visibly damaged. A few years later, they installed a drop ceiling, a secondary ceiling that hangs below the main structural ceiling to make heating and cooling more efficient. Between the installation and the accident almost 10 years later, the Hauerwases neither inspected the plaster ceiling, knew about any problems, nor made any repairs to it. After the accident, Richardson sued the bar and the Hauerwases in Iowa State Court, seeking to recover under a theory of premises liability. Richardson claimed that he was an invitee and that the defendants failed to maintain the premises in a reasonably safe condition for him. The defendants moved for summary judgment. The trial court dismissed the suit on their motion, finding no evidence that they knew or should have known about the dangerous condition of the plaster ceiling. The Intermediate Appellate Court affirmed, and Richardson appealed to the Iowa Supreme Court.